Alright, hi everyone. My name is Johanna Weiman. Hopefully everyone knows me by now since we do have such a small class. Today the case I will be presenting research on is the case of Roof versus Ace Tractor Company and Mega Metals. The jurisdiction that I'm presenting on today is Illinois. The assignment on eCourseWare stated that we should be using the IRAC method, IARIC method for our research. For clarification, for myself and my viewers, I would like to state that IRAC stands for Issue, Rule, Analysis, and Conclusion. I've included a little image here of the IRAC method that I found online. There are two issues presented in the case of Roof versus Ace Tractor Co. and Mega Metals. The first issue concerns whether or not Mega Metals is liable for royalties failures. Moreover, it concerns whether or not royalty was an agent of Mega Metals. The second issue of the case pertains to whether or not Ace is liable for the failures of royalty builders. Furthermore, it pertains to whether or not royalty is an agent of Ace. Mason Roof, represented by his parents, is in court with a lawsuit against royalty builders and Ace Tractor Company. Roof's parents are asking for the court to find both Mega Metals and Ace vicariously liable since royalty was working on their behalf when Mason's injuries occurred. At this time, I would like to define the term vicariously liable as found in Black's Law Dictionary. I have a physical copy of the dictionary next to me, but for presentation purposes, I'm going to show you the electronic version of the dictionary. The word vicarious is defined as performed or suffered by one person as substitute for another, indirect or surrogate. The term vicarious liability means liability that a supervisory party, such as an employer, bears for the actionable conduct of a subordinate or associate, such as an employee, because of the relationship between the two parties. In this case, Mega Metals would be the supervisory party and Royal Builders would be the subordinate. In the case, usually a person who hires an independent contractor is not liable for the acts or omissions of the independent contractor. This is shown in the 2003 case of Shaughnessy v. Skinder Construction Co. I have cited it on eCourseWare for those who wish to take a look. However, one of the exceptions to this rule is stated in Section 414 of the Restatement Section of Torts, which I put a picture of right here. One who entrusts work to an independent contractor, but who retains the control of a part of the work, is subject to liability for physical harm to others for whose safety of the employer owes a duty to exercise reasonable care, which is caused by his failure to exercise his control with reasonable care. I found an article written by someone named Terrence Gooley, I'm pretty sure that's how you pronounce his name, I might be wrong, that applies to this that I wish to share with everyone. Gooley says, a reading of the cases which have applied to Section 414 establishes that the authority to stop the work for safety reasons is the most important factor courts consider when determining whether a defendant has retained the requisite degree of control necessary to impose liability. This rule stated above is where the answer to Issue 2 of the case lies. In the case of Moorhead v. Mustang Construction Co., the court found the existence of a duty under Section 414b, such to defeat a motion for summary judgment since the general contractor knew of the dangerous conditions / unsafe work practice involving a ladder before the accident actually happened. This statement that I just read was from Gooley's article that I cited on eCourseWare. I'm also linking the aforementioned case on eCourseWare for everybody to look at. This is the holding that answers legal issue number 1 on the case on whether or not Mega Metals is liable to Mason Roof. So in the chapter number 1, we talk about agents, and in reference to who is an agent to who, I would like to mention the definition of agent in our textbook that states an agent is the person authorized by the principal to act with third parties on the principal's behalf. So if anybody wants to look at that definition, it's just on page 2. And in this case, the principal would be Mega Metals, and they're contracting with Royal Builders to do the roof work, and then Royal Builders is their agent. The employees of Royal Builders are the third parties. Royal Builders have actual authority to do the roofing work based on the contract that exists between ACE and Mega Metals. The existence of actual authority can be found in the case of FDL Foods Incorporated versus Kokesh Trucking, which I've also listed on eCourseware for everyone to look at. And when it comes to Royalty being an agent of ACE, Royalty Builders is the third party, and Mega Metals is the agent of ACE. So now I'm going to explain how I got to my answers to the legal questions by using the facts of the case. There are 4 parties present in this case: Mason Roof, represented by his family, since he's 16 years old, Ace Tractor Company, Mega Metals Roof Supply, and Royalty Builders. So for the rest of this presentation, well, for the next part, I'm not going to use any slides because all the information that it would end up being too verbose, and I want to make it sure that it's under 50 words. So I'm going to go ahead and talk a little bit about the facts of the case. So everyone can reference the case if they're a visual learner. If not, I'm just going to explain it how I understood it. Ace Tractor Company owned a building that needed a new sheet metal work, a roof. And so this picture right here is a new sheet metal roof. They contacted Mega Metals for an estimate. They approved of the estimate and submitted a down payment for the cost of the work. All of the work that was to be completed was outlined in a contract. In this contract, it was written that Mega Metals used qualified subcontractors to do the work. As Mega Metals Company only provides the sheet metal for the work. Ace Tractor Company was unaware that Mega Metals doesn't do the work themselves. However, the fact that Ace did not notice the clause did not remove their liability. All parties have to live with the fact that the company made a mistake by not properly reading the contract clause that stated that Mega Metals sometimes uses qualified subcontractors to do the work. So, the company that Mega Metals decides to use as subcontractors is Royalty Builders. Roy Bricks, who's the sole proprietor of Royalty Builders, is in a relationship with a woman who has a son named Mason Roof, and Mason Roof is 16 years old. And so Roy Bricks hires the 16-year-old Mason to work for his company, Royalty Builders, for them in the summer in order to keep him out of trouble, as 16-year-olds like to do. And so in presenting this case, I feel like the audience, like my classmates, can really gather that Mason has no experience as he's never worked in construction before and was hired on as an apprentice roofer. Therefore, he wouldn't fall under qualified subcontractor as stated in the clause in the contract. It can be argued that Mason was deemed qualified by the owner of Ace Tractor when he was told later in the case that he was doing a good job, but due to the facts of the case, evidence points to him being unqualified. Royalty Builders stopped using safety equipment that protected them from falling years ago because it slowed them down and they had the apparent necessary experience to be safe without it. So since Mega Metals frequently contracted with Royalty Builders for 70% of their work, it is unlikely that Mega Metals did not know of the lack of safety equipment, and since Mega Metals still worked with the company knowing that they don't use safety equipment, some liability must fall on them. The owner of Ace Tractor Company stops by to inspect the work being done by Royalty Builders and comments on how efficient the company was with doing their work. He takes time to specifically comment on Mason Roof doing a good job. As Mason Roof looks down at the owner of the Ace Company to give him a thumbs up, he steps on a loose piece of sheet metal and falls 25 feet onto concrete, seriously injuring himself. Liability comes into play with Ace Tractor Company as well, since the owner witnessed the safety equipment not being used and didn't do anything to correct it. Now that I've analyzed the facts of the case for my audience, I will now provide my conclusion as well as address the answers to the 2 legal issues outlined in the case. Okay, so who's liable for what? When doing my research, I found that Section 414 of the Restatement Second of Torts gave me the answers to both legal issues on the Roof versus Ace Tractor Co. and Mega Metals case. I find that the answer to both issues is yes. Mega Metals had some liability for Royalty's failures. This holding can be found in Comment B of the Restatement of Torts. I addressed this in the Rules section of my research. Mega Metals knew that safety equipment wasn't used by Royalty and continued to let them do the work. The court should find that Mega Metals had some liability for Roof's injuries. we can't determine how much of this liability will be placed on them. And, as if you were to imagine a court, you can imagine that some of the liability would be placed for Mega Metals. And then as for legal issue 2, yes, Ace Tractor Co. also have some liability for royalties failure as well. This is outlined in comment C of the Restatement of Torts as shown in the rules section of my PowerPoint. The owner of Ace spectated the work being done by Ace Tractor Co. and saw the lack of safety equipment, yet he didn't do anything to change what he saw. So that shows that the court should also find that Ace Tractor Company has some liability for royalties failures as well. Okay, well, thank you so much for listening, and I hope everyone has a good night.